So. Session beginning. Yes.
Yes, ma'am.
No, please, Your Lordship, Lordship, I beg to mention item number 9 and 10. In item number 9, I filed my affidavit already. But in item number 10, I'm yet to receive instruction. So Lordship, I pray that this matter may be listed after vacation to receive instruction.
My lord, may I please, I'm appearing on behalf of respondent number 24 for the first time, lordship, in item number 10.
10.
I filed my power, lordship.
Okay.
My name may be reflected in the cost list, lordship.
And who is put a petitioner? In item 9 and 10?
Item number 10.
Okay. You're in 10.
And 10.
Anybody in 9? Okay.
My lord, I'm
Mr.
appearing private respondent number 19 to 23 and 25 to 101.
In which item?
Item number 10.
19 to 23.
Yes, my lord. And
And?
25 to 101.
25 to 101.
My lord, in item number 9, I'm appearing on behalf of Mr. Dishwasher.
Mr.
Donato.
Learned Counsel for the petitioners in item 9. And MS of Mr. Limao. Learned Counsel for the petitioners in item 10 are present. Poster. MS V. Supri, Learned Additional Advocate General, Nagaland, has submitted that the counter affidavit on behalf of the state respondents has already been filed in WBC number 187, 2024. Poster. MS Supri has further submitted that insofar as the petition WPC number 239, 2024 is concerned, she is yet to receive the necessary instructions to file the counter affidavit on behalf of the state respondents and has thus sought for further 4 weeks time to obtain the necessary instructions and to file the counter affidavit on behalf of the state respondents. Full stop. Mr. Tosi Longkumar.
Yes, lordship.
Learned Counsel has submitted that he has entered appearance on behalf of the respondent number 10,
24.
24
in item number 10, lordship.
Okay. By filing power today. Post of MS
Serenity.
Learned Counsel has submitted that she represents respondent number 9 to 23 and 25 to 101. Full stop. Okay, you want to file any return?
Yes, Lordship.
Counter?
4 weeks
Yes,
time may be
madam.
granted, Lordship.
Do you want to file any counter affidavit?
Yes, my lord.
Okay. Both Mr. Longkumar and Ms. Benso have also prayed for 4 weeks time to file their respective counter affidavits. The prayers made on behalf of the respondents are allowed, release the cases after 4 weeks.
Your Lordship, the interim order passed during the ballot fund.
In both the cases or one?
Item number 10.
The interim order, if any, passed in the read petition, WBC number 239, 2024, shall continue till the next date.
Much obliged, Lordship.
Your Lordship, I beg to mention item 12 from the hearing list, Your Lordship. This is a joint prayer on behalf of the petitioner as well, Your Lordship. This matter may be listed after vacation.
Item number
12 from the hearing list.
on the joint prayer of the learned council for the parties, lays the case after the ensuing winter vacation on a date to be expired of this.
Much obliged, Your Lordship.
Yes, madam.
Your Lordship, I beg to mention item number 6, 7, and 8.
6, 7, and 8.
Your Lordship, I'm yet to receive the pairwise comment, so kindly grant me 3 weeks time to file my affidavit.
Who is the for the petitioner?
6, 7, 8.
Yes, you represent Joshua Shoki. Mr.
No, to yep, no.
Learned council representing Mr. Joshua Shoki, learned council for the petition is present. Miss
AIME.
AIME. Learned state council. In all the cases,
Yes, Your Lordship,
Okay.
6, 7, and 8.
the state council has submitted that C is yet to receive the necessary instruction to file counter affidavit in these cases and has thus sought for further 4 weeks time to obtain necessary instructions and to file the counter affidavits. A prayer made by the Learned State Council stands allowed, release the cases after 4 weeks. Immediate to fix by others.
Much obliged.
Lordship.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item number 5.
Why?
Your Lordship, since the leading counsel has a personal emergency today, if the matter can be fixed on 12th.
Madam, 12, okay. 12, on the prayer of Miss
Conley, which
Learned Council appearing for the petitioner, raise the case on Sweds. 12. Yes. Anything, any prayer?
Proposal, item number 1.
Your Lordship,
Hmm.
this application is praying for extension of time for a period of another 60 days, Your Lordship, to comply with the court's order dated 10/9/2024, which was passed in 117/23, Your Lordship.
What is the direction?
Your Lordship, the direction was that as per the order, the court directed the deputy commissioner to set up an inquiry to ascertain whether the private respondent was a landowner or a descendant of the landowner. Your Lordship, and to complete
Who
the,
was the learned counsel for the petitioner in 117?
Lordship.
You're there?
Yes.
And who was the learned counsel for the respondent number 5?
I'm
Okay. So what do you say?
no objection.
No objection. Art MSA IME. Learned government advocate for the applicant. And MS, who was the petitioner? Lichamo. Okay, you're there. Your name?
Simile.
Simi, learned counsel for the opposite party number 1. And MS,
Ayala Imchen.
learned counsel for the opposite party number 2. Full stop. The opposite party number 1, as the writ petitioner, preferred a writ petition, common WBC number 117 of 2023, wherein the opposite party number 2 was implemented as party respondent number 5. Full stop. The applicant herein was implemented as party respondent number 3 in the writ petition WBC number 117 2023. Full stop. Para. The writ petition was preferred, seeking quashing and setting aside of a notification dated 21/12/2022, issued by the Directorate of Nagaland for Agriculture, Nagaland, whereby the respondent number 5 therein, that is, the opposite party number 2 herein, was appointed as Mali in the establishment of the sub-divisional agricultural officer within bracket SDAO, bracket close, Bhakti, district, that's Kohima. Full stop. A further direction was sought for to appoint the petitioner to the said post on land ownership basis. Full stop. Para. After hearing the learned counsel for the parties, and on consideration of the matters on record, the writ petition was disposed of by judgment in order dated 10/9/2024. Full stop. A direction was passed to the Deputy Commissioner Ukha or an officer authorized by the Deputy Commissioner, Ukha, to make a proper inquiry to ascertain whether the respondent number 5 therein, that is, the opposite party number 2 herein, is a landowner and stroke or a descendant of the landowner who had donated the land for the establishment of the agri farm at Bhakti Valley in Ukha district. Full stop. It was ordered to complete the inquiry within a period of 60 days from the date of receipt of the said order, and to submit the report to the Deputy Commissioner Ukha, submit a report thereafter by the Deputy Commissioner Ukha, that is the applicant herein, to the Director of Agriculture, Nagaland, forthwith. Full stop. It was further observed that in the event, it has been further observed that in the event it is established from the inquiry that the opposite party respondent number 5 is not a landowner, the department shall at the earliest and without any delay advertise the post in question, inviting all eligible candidates, including the petitioner and the respondent number 5, to participate in the selection process to be conducted by the government stroke department in accordance with law. Para. The instant application is preferred by the applicant stating that The judgment and copy of the judgment and order dated 10/9/2024 was received by him, received at his office on 27/9/2024. Full stop. As per the order, comma, the inquiry was to be completed within 60 days from the date of the receipt of the order. And accordingly, comma, the, or not full stop. It has been averred that the inquiry, comma, as directed by the judgment and order dated so and so, comma, is still in progress and would take some more time to complete it. Full stop. As the period of 60 days from 27/9/2024 has expired already on 27/11/2024, comma, this, by this application, the applicant has sought, has made a prayer to extend the time period for completing the inquiry by another 60 days. Full stop. The prayer made in this application is not opposed by the learned counsel for the opposite party number 1 and opposite party number 2, comma, where the writ petition and the respondent number 5 in the writ petition, comma, WBC number so and so respectively. Full stop. Para, as completion of inquiry comma, directed by the judgment and order dated so and so, comma, is necessary in order to ascertain the eligibility of the respondent of 5 to ascertain the claim of the respondent of 5 on the basis of WADA policy frame for the landowners and also to decide as to whether the post, as to whether any advertisement would be required to be published for filling up the post, comma, this court is of the considered view that the prayer made is in this application request to be allowed. Post up. Accordingly, come on, this the instant application is allowed by providing further 60 days time to the applicant to complete the inquiry, comma, as directed in the judgment and order dated 10/9/2020.
My apologies, Lordship. In the earlier item number 9, raised in interim.
In the earlier, okay. 9. Interim orders, if any, shall continue till the next date of this.
Much obliged.
For motion, item number 2.
May I please, Lordship?
Yes.
Lordship, in the state of Nagaland, the land holding system is that the land belongs to the people. Therefore, the state of Nagaland had to acquire land from people for any development purposes. Lordship, Lordship, here the land of the petitioner's father was taken. In fact, Lordship,
Where from we can get that you are the descendant of the landowner?
Lordship,
Any document, supporting document?
Lordship may come to page 21, Lordship.
21.
Lordship, this is the village council signed by
It
the
is not
chairman.
saying under landowner compensation. It is not saying anything.
Lordship, second paragraph, Lordship. Therefore, we humbly request your esteemed authority to kindly accept this letter of recommendation for further reprisal, as he is the sole landowner of the sub-center.
Sole land.
Sole landowner of the
Okay.
sub-center, Lordship.
What happened?
Lordship, as such, Lordship, as per the policy framed by the government of Nagaland, Lordship, the notification dated 5th March 2018, Lordship, that is at page 13. An extra one, Lordship. Operative part is at the
Already appointment is made.
appointment is made, Lordship, but I'm telling you his appointment, Lordship.
He joined.
Lordship, the
It will be
respondent
subject
is
to
joined,
the
Lordship.
outcome then.
Lordship, sir, the outcome, Lordship. Lordship.
Yes.
Lordship,
Anything?
at this stage, notice can be issued.
You represent all the state
Yes,
respondents.
Lordship.
Heard Mr. Fonseca Hotel, learned counsel for the petitioner, and Mr.
Ajungli.
Learned State Council for the respondent number 1, 2, and 3. Full stop. The petitioners has claimed that he is from the family of the landowner who donated their land for setting up of the office of
Shina sub-center, Lordship. Medical center, sub-center, Lordship. Mon district. Sub-center, Shina Tenten.
SHEANGHAH. Sub-center
Lordship. Under CMO Mon.
under the Chief Medical Officer, Mon. Full stop. In this petition, the petitioner has challenged the order of appointment,
September 12th, 2024.
the order conveying government approval dated 19/8/2024, and the order of appointment made in favor of the respondent number 4 dated, order dated so made in favor of the respondent number 4. Order dated 12/9/2024. Annex 6 within bracket, Annex 7. Full stop. It is the contention of the petitioner that disregarding the claim of the petitioner on the basis of the notification dated 5/3/2018 for the state post, for the post of Malik,
Lordship, medical attendant.
for the post of medical
attendant.
attendant
Lordship, medical attendant.
in the Siengda Tangten Sub-Center Mon. The state respondents have appointed the respondent number 5
For Lordship.
without any kind of advertisement, without publication of any kind of advertisement, and without any kind of selection process.
Lordship.
Issue notice returnable on 29
Lordship.
2025. As Mr. Swetzer has appeared, accepted notice on behalf of the respondent. Then number 1, 2, and 3, issues of formal notice to the state respondent stands displayed. Land Council for the petitioner shall, however, furnish requisite number of extra copies of the petition along with annexer to Mr. Swenson and State Council within 3 working days from today. the petitioner shall take steps for service of notice under the respondent number 4 by registered post AD within 3 working days from today.
Lordship, the appointment of the respondent number 4 may be according to the
Having regard to the projection made, comma, it is observed that the appointment of the respondent number 4 will be subject to further orders of this week.
I'll back.
The supplementary procedures, item number 13.
May I please, Your Lordship?
Yes.
Lordship, I've informed the council for the petitioner, but you couldn't appeal the appeal today as well. My lord, but regarding this IA,
Is there any order required to be passed?
my lord, since I'm not in this case, my lord, and I'm not well conversant with the fact of the case.
Yes, need not be because in our brief,
My
that
lord,
is not there, what you are seeking correction.
My lord, in paragraph 3 of WPC
I have asked you to compare yesterday. That was not there, that those
My lord,
words are not there.
it was there in WPC 234 of
Huh?
234 WPC 234 of 2023.
234,
Yes, lordship.
any other petition?
Yes, lordship.
But in the subsequent petition,
not there,
no.
not there. As lordship has pointed out, no order is required to be passed, in fact.
Two 34.
Yes, lordship.
Read petition. So where do you find it? 234. Yesterday I saw checked only 266. Paragraph 3. Please read, where did you find this petitioner was made absolute and sole legal owner?
My lord, there are two read petitions
I have seen.
filed by them. In WPC 234, if lordship comes to page 5, first sentence,
Paragraph?
page 5, first sentence, paragraph 3, page 5, first
Let me
sentence.
check. 234, I have ended over the brief. You also see,
Yes, I-
in the court's brief. I don't know what is there in your brief. What I am concerned with, what is there in the court's brief.
Yes. Person. They just want to correct two words, absolute and sole legal honor. They have wrongly stated, that is what they're trying to say.
Heard, Mr.
Nisika Jishi, lordship.
Nisika,
Jishi, lordship.
learned counsel for the applicant, read petitioner. And Mr. Ajo, learned counsel, state counsel for the opposite party. That's respondent.
1 to 3.
1 to 3. Poster. The applicant as a read petitioner has preferred the accompanying read petition WPC number 234 of 2023, seeking certain reliefs. Full stop. The instant interlocutory application is preferred by the applicant read petitioner seeking certain amendments. Seeking certain corrections. In paragraph 3 of the read petition. Full stop. According to petition, applicant read petition, comma. Certain inadvertent errors have been kept in inadvertent typographical errors have been crept in paragraph 3 of the writ petition WBC number switch. In paragraph 3, at one place in paragraph 3, comma, an expression, comma, quote unquote, sole legal owner. No, sole legal owner. In the repetition, comma, paragraph 3, read is under. This application. By this application, comma, the applicant writ petition has stated that the paragraph 3 in the accompanying writ petition ought to have been read as under. Bold. With the above projection, comma, the applicant writ petition has paid for allowing him to then it will be again amended writ petition.
But they are not praying for amendment, that's what I'm saying.
Ah.
They're simply asking for rectification.
But rectification, they said sole legal owner, lessee, and where the word absolute will go.
My
There is
lord,
a word absolute also. Usually drafted petition. Application.
my only,
Full stop. Mr. Joe, Reliance State Council has submitted that the applicant writ petitioner, subsequent to filing of the writ petition WBC number 234 of 2023, comma, had preferred, has also preferred, has preferred another writ petition, comma, WBC number 266 of 2023.
my lord.
Full stop. Wherein the paragraph 3 correctly, no? Is it correctly? Wherein and in paragraph 3 there too, comma, because it will prolong the matter.
That is what,
Amendment is
yes,
allowed.
that's why. If that is allowed, it would run,
Unnecessary prolong.
lordship, the burden for the state is, this is for development. And lordship is aware, it is like Hornbill, many VIPs are coming.
The expression absolute and sole legal owner is missing. Full stop. By an order dated 30/11/2023 passed in the writ petition WBC number 266 of 2023, both the writ petitions, WBC number 234, 2023 and WBC number 266 of 2023 were ordered to list together. And on and from 5/12/2023, both the writ petitions are being heard together. Full stop. In WBC number 264, 2023, paragraph 3 read as under. Paragraph 3. Para. As in the subsequent writ petition, WBC number 264, 2023, the applicant writ petitioner has projected his position correctly. Mr. Joel and State Council has submitted that the instant application seeking virtual amendment is a ploy to delay the writ proceedings, delay consideration of the writ petitions, as the applicant petitioner is enjoying an interim order. First, para. This court finds force in the submission of the State Council. First off, it is noticed that the applicant writ petitioner is enjoying an interim order. First off, since in the subsequent writ petition, the applicant petitioner has projected his position correctly, as admitted by Mr. So-and-so, learned counsel appearing for the applicant petitioner, there appears no necessity to seek amendment in the writ petition, as such process will unnecessarily prolong consideration of the writ petitions. First off. It is observed that for all intents and purposes, and as from the lease agreement is there. As from the lease deed agreement dated 6/9/2022, it is apparent that the applicant petitioner is referred to as the lessee. And It is a Department of
Tourism, my lord.
Tourism, Government of Nagaland.
Correct.
As the lessor has been referred to as the sole legal owner of the department asset, namely restaurant, within bracket, catering services located at Tourist Lodge,
Dimapur.
District Dimapur. We find no necessity to allow the prayer made in this interlocutory application, preferred at this stage, preferred as far back as on twelve 10/2023, at this stage. Full stop. It is clarified. It is, however, clarified that for all intents and purposes, the applicant petitioner is to be treated as a lessee
My lord.
and not as an absolute and legal.
My lord will appreciate one aspect. I have filed affidavit in opposition. This is purely civil in nature. In any case, this is not maintainable, my lord.
Absolute, not as quote, absolute and sole legal owner of the department asset, namely restaurant within bracket catering service at Tourist Lodge, Dimapur.
Yes, my lord. Lordship, this method,
With the above observation, this interlocutory application stands disposed of.
my lord,
Okay, this is disposed of.
my lord.
For all intended purposes, will not be treated as an absolute. Otherwise, you will file another amended petition.
And my lord,
You will ask for 4 weeks, 6 weeks time.
and my lord,
In the meantime, winter vacation.
there is no prayer for amendment.
Absolutely abuse of the process.
There is no prayer for amendment also.
Huh?
There is no prayer for amendment also, my lord. Lordship will appreciate here in Nagaland, there are only 2 tourist lodges. One is Kohima and one is.
Yes, are you ready for hearing or not?
No, my lord, I'm not in this case, my lord. I'm appearing on behalf of counsel for the petitioner, my lord.
In earlier occasion, he made the same submission. That counsel engaged in this case is not present, so he is the substitute earlier. So today also he's saying the same thing. And he is projecting his case. Now, my lord will appreciate. There are only 2 tourist lodges in Nagaland, like this occasion. Kohima, we have already leased out to Hotel Polo Shillong. They have started the construction.
Okay,
Dimapur-
Mr. You can do one thing because council is not present.
Yes.
And then again, there will be difficulty.
My lord,
We'll put it on Monday.
Monday. Very well, my lord.
You pressed for vacation of
Very
the
well.
interim order?
I have filed. I have filed also.
You have filed
My
affidavit
lord.
or I also,
I also.
vacation?
Yes, I filed.
Where is that?
Not listed today, that's one thing.
Okay, you tell that.
Monday.
Okay, writ petition.
Monday.
Okay.
Because
In the writ
in
petition.
any case, this civil dispute, they cannot come before the record. I have filed a affidavit.
Okay, you have filed already an
Yes.
interlocutory application.
I have filed.
Seeking
I have-
vacation
I
of the
have filed.
interim order.
I have filed.
Okay, we'll put it on Monday.
My lord, my lord.
Mr.
Nsukachi, lordship.
Learned Counsel, writ petition, representing Mr. Joshua Seki.
H.H. Kinimi, lordship.
Hmm?
H.H. Kinimi, lordship.
It says Kinimi. His name is there. Item number? Huh?
Item 13, 14, my lord.
Learned Counsel representing Mr. H. Kinimi. Learned Counsel for the petitioner is present. First, Mr. Ajo, Learned State Counsel, has submitted that an interlocutory application seeking vacation,
My lord.
stroke modification of the interim order has already been filed on behalf of the state, and the same has been numbered as numbered.
Number, higher number.
You get it? If there is any defect, when it was filed,
Yesterday, Lordship.
has been filed on so and so. And has sought listing of the case, listing of these petitions along with the
My lord.
interlocutory application filed on so and so. Comma, on. Ninth,
My lord.
ninth. Ninth, yes, Kinimi will be available or not?
Yes, I'll inform him, my lord. I'll inform him.
Or we can put on 12th,
No, my lord, no problem.
12,
Okay,
Because
my lord.
only his interest is asking money from the department.
12.
Okay, my lord.
24. Come, tell him to come for hearing also.
Yes.
Okay, my lord.
That all.
That will be better.
Yes, my lord.
If pleading has been exchanged already, you have filed your affidavit. Reply?
No, they have no reply.
Hmm?
But I have raised preliminary objections. So on that, once preliminary objection decided, then it may not be required to go into the merit of the case also, because this is purely civil in nature.
If the applicant, if the petitioner desires to file any affidavit in reply to the counter affidavit filed on behalf of the state respondents, comma, the same shall be filed on or before 11/12/2024 without fail,
Major,
and no further opportunity will be
Yes.
granted for filing
this has,
any affidavit in reply.
this has stalled the progress of the work. Major,
Obliged, lordship.
Item number 3.
Lisa के स्कूल में 12 item number. Yes, any progress?
Lordship, no progress. I may be allowed some few days time, Lordship.
Huh?
Some few days time. I may be allowed some few days time. So
Yes, madam. Otherwise, nothing is there in your petition. We have tried to put some oxygen.
I'm communicating with the department.
Imchen is not coming up with any positive.
No, I'll definitely bring in the decision of the department and let this matter will come up on the Lordship. 12.
12. Okay.
I'll try to
Find out
bring it up.
something. If
And Your
he has
Lordship,
completed the work, at least you should give some
that is why.
hearing to him. Give a hearing.
We need consultations, Your Lordship. Department needs consultations.
Huh. Give a hearing and
Department has to take a
consultation.
decision. Department has to take a
He is a
decision.
private person. He has invested his money for a
Correct.
public project.
We appreciate that. Yes, correct, correct. Lordship,
Otherwise, no one will come and execute the project for the state.
yes, yes.
It will remain lesser developed. If you are not
Yes,
paying the money to a contractor who has invested his money to execute a public project,
right.
otherwise legally not possible to adjudicate the writ petition. Adjudication is possible, but positive direction is not possible. It will be dismissal only, non-alternative. Okay. Miss
Comely.
Comely, learned counsel for the petitioner, and Mr. Moa Imchen, learned
Yes, yes,
state
Lord.
counsel for the respondents are heard.
Lordship,
Mr. Imchen, learned state counsel, has submitted that instruction from the competent authority in reference to the earlier order dated 4/12/2024 is awaited. Full stop. He has sought listing of this case on 12/12/2024 in order to enable him to obtain the instruction in order to make an endeavor from his end to obtain the instruction. Also, I'll list the case accordingly on so and so. Similarly, earlier order will be different. This is item number 3. Earlier order is 4/12/2024. Now, next one. Next one, there are two. I think. Same thing. One came one day,
Lordship,
one came from the next day.
WBC
This is 3/12.
WBC
It would at a 3/12. I got order to sell over there.
Lordship,
4/12 at a 3/12.
Lordship, WBC 40 of 2024 must also be included with this too, because analogous matter. WBC 40 stroke 2024.
Mr. Imchen has further submitted that he'll obtain another repetition. Come on, WBC number
WBC number 40 stroke
40.
2024.
of 2024 be also listed along with WBC number so and so on 12/12/2024, as the issue involved therein is similar to the one involved herein. First of, he has further submitted that he will also obtain instruction relating to WBC number 40 of 2024
Lordship.
on the next date of listing. List this repetition along with WBC number 40 of 2024 on 12/12/2024.
Much obliged.
Item number 11.
Yes, sir.
Lordship, while serving as LTA counter assistant, Lordship, I was terminated from service, Lordship.
Oh, it is there. Okay, okay. I have not seen because of this.
I was initially appointed
Where
as
is your repetition? Okay, take me through the annexer.
Lordship, page number 14, Lordship.
You are
Page number 14, Lordship.
Jubeni Jet Kikon.
Lordship,
Okay.
there are only 3 annexures in this petition,
Hmm.
Lordship. May I read it, Lordship? This is the order dated 28 February 2017. In the interest of public service, Shrimati so-and-so, daughter of so-and-so, is hereby appointed as LDA counter assistant on casual basis at General Administration Rest House worker in the scale pay of so-and-so, plus all other allowances as are admissible from time to time with effect from 1st March 2017 till further order. The appointment is purely on temporary casual basis and shall be terminated without any further notice. This is issued by the Deputy Commissioner Worker, Lordship. Now, Lordship, page number 18, Lordship. Page number 18, that last page, Lordship. This is order dated 9th March 2022, Lord. If Lordship got it. Page 18, Annexure C.
Yes.
In pursuance of the Commissioner Nagaland Kohima letter number so-and-so dated 1st March 2022, the contingency stroke casual appointments made in the office of Deputy Commissioner Worker on exigency and as stopgap arrangement till the conduct of next district level recruitment board DLRB with the approval of the Commissioner's Office Nagaland Kohima are hereby terminated with effect from 1st March 2022. Now the petitioner's name figures at serial number 1. Designation is LDA counter assistant and place of posting is rest house worker. Note, this impugned order is referred to letter 1st March 2022, the decision of the Commissioner, Lordship. Page 15, Lordship, and Lordship will find the type copy at page 16. This is 1st March 2022. It was communicated to all the deputy commissioners of the districts in the state of Nagaland. Subject is termination of all appointments made on contingency casual basis till DLRB regarding. So till that recruitment process is conducted, their service to be terminated, Lordship. On the subject cited above, I am to refer to Finance Department OM dated so and so, and Directorate of Treasuries and Account Nagaland circular number dated so and so, and Finance Department OM number so and so, wherein the government of Nagaland has decided to introduce payment of salaries in wages through e-pay bill system based on personal information management system. The government has reiterated that relaxation from the purview of e-pay bill system will be considered till the remuneration of February 2022 to be drawn March 2022. No further relaxation will be considered beyond that period. In this regard, it is to state that with the approval of this office, certain contingency casual appointments were made in the office of Deputy Commissioner on exigency and as stopgap arrangement till the next DLRB. These appointments being temporary are not eligible for PIMS registration. Further, with the advertisement of recruitment of various posts through DLRB, the posts occupied by them are extended up to 28th of February 2022 and hereby thereafter liable to be terminated. In view of the above, you are directed to immediately terminate all appointments made till so and so, repeat 1st March 2022. This is for information and strict compliance. Failure to take necessary action will be strictly the responsibility of the respective deputy commissioners. So that was the direction, and in terms of the direction, the impugned termination order was issued on 9th March 2022.
So what is your prayer here?
Lordship, there are two conditions communicated by the commissioner. First is due to introduction of the e-pay payment system, the PIMS is required. Second is stopgap arrangement, Lordship, till the conduct of next DLRB. Lordship, my respectful submission, and as on today, the instruction as the instruction for my client, the DLRB, in respect of Deputy Commissioner's Office, WOCA is yet to be conducted. My respectful submission and limited prayer before this honorable court is, if I may be allowed to continue till such recruitment process is conducted, Lordship.
But if there is need or not, there is necessity, you cannot determine a necessity to keep
Yes,
you
Lordship.
continuing
Yes, Lordship.
in the post is of the solely of the employer. What kind
Yes.
of right you have
Lordship,
accrued as a casual
Yes,
employee,
Lordship.
please?
Lordship, I understand that.
What kind of right you have accrued?
I was the only employee assigned to look after the rest house in WOCA, Lordship.
Because otherwise, in a case of employee and employer.
Yes, Lordship,
it is
I
the-
understand that. Lordship, I
it is the
understand that.
employer who decides whether I need them or do not need them.
Lordship.
But in case of this employees coming within the purview of 311,
Lordship.
say state government, civil
Lordship.
servants,
Lordship.
say public sector undertaking employee or
Lordship.
industrial workmen,
Lordship.
right? They acquire a status.
Lordship.
Under the industrial law, they have certain rights
I agree.
provided by law.
I agree.
And for civil servant and others, they are governed by a set of rules.
Lordship.
They are members of service, they attain certain status, they have been granted some constitutional protection,
Lordship.
309, 311. But so far as casual employee is concerned,
Lordship.
it is completely a contract kind of thing.
Lordship.
And it is at the sweet will of the employer.
Lordship.
If the employer says that I do not need them,
Yes.
the court cannot force them
Lordship.
to, yes, you take this employee. Because there are many implications.
Lordship.
Your status is not that court can protect you.
Lordship, if my service comes into the purview of 311, I could have argued on the principle of
Yeah,
natural justice.
Fully,
Lordship.
that without DP, without any kind,
Exactly,
you
Lordship.
can do,
Yes,
cannot do anything.
But
And court
Lordship-
will definitely, if instead of casual or contingency, if you are a regularly appointed employee,
Lordship.
on the first day you would have got stay. So These are difficult years, sir.
Lordship, if I may be allowed to refer just one, a short authority, Lordship. It was 1988 supply SSC 428. Just a short order, Lordship, by the Honorable Apex Court. Rajabinder Singh's case, Lordship. May I read the entire order, Lordship? It's just a few paragraphs. The petitioner is an ad hoc lecturer. If Lordship got it, Lordship. He was appointed for a term. His grievance is that he is likely to be removed from service so that he may be deprived of his vacation salary. It appears that the practice of the respondents is to appoint fresh people every time. This court, in a number of read petitions are referred, Lordship, has allowed the ad hoc teachers to continue in service until persons regularly selected by the PSC are appointed to the post. The respondents ought to extend the benefit of the order to all other ad hoc lecturers. It is not proper to drive them to this court for securing similar relief. We make it clear that the petitioner and other similar ad hoc teachers are entitled to the benefit of the order of this court made in the aforesaid read petitions. These observations, in our opinion, are sufficient to safeguard the interests of the petitioner. The read petition is accordingly disposed of. But even in this case, the petitioner was an ad hoc lecturer. At least still that relief, Lordship.
Because
such
practice was
recruitment
that
process.
normally during, that was prevalent in Assam also. I think it is still prevalent.
Lordship,
That ad hoc teachers are appointed by college governing bodies.
Lordship,
And when the long vacation comes, they are released
Lordship.
to save the money. Again,
Lordship.
they are appointed.
Freshly
when the
appointed.
New session begins.
Lordship.
But
Of course,
question
the
is,
facts and
this is
circumstances.
before Uma Devi.
Yes, Lordship. Lordship.
After Uma Devi, everything is governed by Uma Devi.
And my prayer is also not to make my position permanent, but at least till such time the recruitment process is conducted, Lordship.
This will be.
Give a direction at least to consider by the Deputy Commissioner, Lordship.
We can only observe if any necessity arises.
Yes, Lordship. Yes, Lordship.
In future, in the office, and if any application is made by the petitioner
Lordship.
for consideration
Lordship.
for his engagement,
I'll be obliged,
the
Lordship.
state, the respondents shall consider it taking into account his previous services.
Lordship.
Gained.
Your Lordship, the problem is,
Consider means not
yes,
Exactly.
yes, I know.
a
Your Lordship.
point.
Yes, your
Exactly,
Lordship,
Lordship.
yes, your Lordship, I got it, your Lordship. However, the problem is, your Lordship, there's one problem. All this order passed by the Deputy Commissioner, your Lordship, to all the state, to all the districts. It is, this was brought out mainly because of the PIMS, your Lordship.
Mainly,
PIMS, your Lordship, generation of PIMS, because every employee has to get themselves generated in the PIMS, your Lordship. Unless until the employee gets registered in the PIM, salary will not be expressed, your Lordship. That is mandatory now. So now, even if we had compassion for the petitioner, the PIMS will not allocate. That is, and he will not get salary. That is the problem. All these issues come up because of the PIMS only, your Lordship. Your Lordship, I have clearly stated in my affidavit, your Lordship. That is the crux of this
Madam,
petition, your Lordship.
in the state of Nagaland,
Yes, your Lordship.
we find everything is possible in public employment.
Your Lordship, but now it's become impossible, your Lordship, here in
It is.
Nagaland.
Yes, then it is for the better.
Yes, for
But everything we come across every day.
maybe, your Lordship, but now it's very difficult to get registered in the PIMS now, your Lordship, and salary are not being dispersed, your
If you
Lordship.
implement it properly, it is good for the state.
Lordship.
Yes.
And Lordship
And
has
your
rightly
Lordship-
pointed out, there are hundreds and thousands of employees, temporary employees. who are
That's why
still
they are not
continuing in
getting, your
service.
Lordship, and all this, it is getting backlogged.
You are only 5 years. There are many rendering 20 years, 25 years.
How are you, Lordship?
Uncertain future because of
Your Lordship, but however, your Lordship, as rightly observed by this, your Honorable Court, your Lordship, the petitioner was appointed in the year 2017. Now there is an OEM, your Lordship, because of the Uma Devi's case, your Lordship, the government has come out with an OEM banning all contract and casual appointment. Now the petitioner has been appointed after the OEM has been issued, your Lordship. Yes, the petition was, your Lordship, you can come to my annexation 1, your Lordship.
Annexure 1.
Annexure 1 is the office memorandum issued by the Department of Personal and Administrative Reforms on 6
Annexure
June.
1 ban on appointment
On
on
contract.
contract basis. Now see
Yes.
the appointment date.
Yeah, appointment is on 28/2/2017. Your Lordship, so it is after this one, Your Lordship.
There was ban in 2016
Yes, Your Lordship, and
on contract basis,
Your Lordship,
right?
yes, Your Lordship,
So temporary casual basis.
yes, Your Lordship,
In
Your Lordship, if-
2017, petitioner was appointed.
yes, Your Lordship, that's why, Your Lordship.
Nobody follows the law.
That's why, Your Lordship, if you can kindly come to paragraph 3, Your Lordship.
Hmm.
In view of the position brought out above and modification of so and so, it has been decided that no appointment shall be met on so and so. Henceforth, in other words, appointment contract on contract basis is banned. Thus, a post coming within the preview of NPAC can be filled up only by appointing a candidate recommended by NPAC on the basis of open recruitment, and it cannot be filled up even temporarily in any other manner. Any appointment met on contract basis henceforth shall be null and void, Your Lordship. The administrative head of the department and the head of the department concerned shall be responsible to ensure that no appointment is met on contract basis and disciplinary action shall be initiated against them in any of
So
the.
who is the higher authority? Chief Secretary to Government of Nagaland or Deputy Commissioner?
Your Lordship, here, the DCs, they're all under, Your Lordship, of course, Chief Secretary, Your
But
Lordship.
he's not following.
Your Lordship, as you're well aware, there are so many
See-
loopholes.
See, in your copy to 11,
Yes, Your Lordship.
all deputy commissioners.
Yes, Your Lord, all the deputy.
After reading it, he passes this order, appointing the petitioner. After reading this banning order,
Yes, Your Lordship.
all appointments made on contract basis henceforth null and void. And in other way also, it cannot be filled up, even temporarily, in any other manner.
That's why, Your Lordship, there may be hiccups there, but Lordship, the government is
Still
taking
in
up steps.
2017,
If you can come to,
temporary casual basis.
Your Lordship, if you can come to my annexure 2 again, Your Lordship, of course, there is a hiccups here and there, Your Lordship, but the government are actively taking up, Your Lordship. In para 5 of my annexure 2, Your Lordship, again. Further, as per so and so, Your Lordship, appointment on contract ad hoc fixed scheduled work charge are banned with effect from so and so. However, many departments are still sending such proposal to registering in the PIMS in defense to the said OEM. It is therefore reiterated that the PIMS shall not entertain such appointment for registration. Your Lordship, yes, Your Lordship, I agree. But Your Lordship, we are also, the government is also trying to cripple.
What is your age?
Lordship, 30.
30.
Lordship,
We can observe weightage.
Lordship.
Participate in open advertisement. Shall consider giving weightage. Take into account
And Lordship,
the services of the petitioner to explore the possibility of giving weightage for his previous experience.
Lordship,
Like that much only.
Lordship.
Otherwise, nothing. 30, you are young still. You can participate in the
Yeah.
open advertisement.
Lordship.
But this petition under Article 226 of the Constitution of India is preferred to assail a letter number so and so, prayer 8 Annexure B, issued by the respondent number 2 and an order number so and so, prayer B within bracket Annexure C. And full stop, a further direction has been sought for to allow the petitioner to continue in service in terms of his appointment order dated 28/2/2017 2017. Full stop. By the order dated 9/3/2022, the petitioner's appointment came to be terminated with effect from 1/3/2022. Full stop. Para. The factual matrix is in a short compass. Colon, by an order dated 28/2/2017, passed by the respondent number 3. The petitioner came to be appointed as a LDA counter assistant, page 14, on casual basis at General Administration Rest House at Ukha in a scale of pay of rupees 1,000 so and so, plus other allowances as admissible from time to time. WEF 1/3/2017 till further order. Full stop. It was specifically mentioned in the order dated 28/2/2017 that the appointment of the petitioner was purely on temporary casual basis and is liable to be terminated without any further notice. Full stop. On receipt of the order of appointment dated 28/2/2017, the petitioner immediately joined in the post and started discharging his duties. Full stop. Para. After rendering about
5 years, Lordship.
5 years of service as LD counter assistant, the petitioner came across a letter dated 1/3/2022 of the respondent number 2, addressed to all the deputy commissioners, including the respondent number 3. Full stop. Apart from dilating on the issue of payment of salaries and wages through E-pay bill system based on personnel information management system within bracket PIMS, the respondent number 2 by the said letter stated had observed that certain contingency stroke casual appointments were made in the offices of the deputy commissioners on exigency and stopgap arrangement till the completion of recruitment processes through the district level recruitment board.
Lordship.
Post. Observing that these kinds of appointment being temporary, are not eligible for PIMS registration, the deputy commissioners were directed they were intimated that the post occupied by those contingency stroke casual appointees would be were extended only up to 28 to 2022. And thereafter, they should be terminated with effect from 1/3/2022. It was observed that it was further observed that close on the heels of the letter dated 1/3/2022 of the respond number 2, the respond number 3 issued the impugn order dated 9/3/2022, whereby appointments of 7 number of contingency stroke casual appointees made in his office on exigency and stopgap arrangement were terminated with effect from 1/3/2022. First off, the impugn order made mention of the letter of the respond number 2 dated 1/3/2022. Full stop. The petitioner is one of the 7 contingency stroke casual appointees whose appointments were terminated. Full stop. I have heard Mr. Muaz Jamil, learned counsel for the petitioner, and MS Livika, learned state counsel for all the respondents. Full stop. Mr. Jamil, learned counsel for the petitioner, has submitted that in the letter dated 1/3/2022, the respondent number 2 had observed that the post occupied by the contingency stroke casual appointees would be extended up to 28/2/2022, and such a observation was made on the premise that the advertisement for recruitment to various posts through the district level recruitment board was already made. First of all, it is submitted by him that till date, no Lord, advertisement for filling up the post vacated due to the impugned order dated 9/3/2022 has been undertaken, and as such, the services of the petitioner can be extended till recruitment through the DLRB is completed. It is further submitted by him that any other submission?
No.
MS Livika seriously objecting to the prayer made in this late petition. Has submitted that by
Which is my paragraph 5 will be more relevant, Your Lordship. Paragraph 5. Page number 3 and paragraph 7, Your Lordship.
the government of Nagaland, Department of Personnel and Administrative Reforms, government of Nagaland, issued an office memorandum on 6/6/2016 on the subject quote unquote, page 7, ban on appointment on contract basis. Full stop. The OM has, it is submitted by Ms. Liviga, referring to the said office memorandum that the state government has decided not to fill up any post even temporarily, comma, either on contract basis or in any other manner, comma, other than by making an advertisement and by undertaking a selection process. Full stop. By referring to another office memorandum dated 5/7/2019, Ms. Livica has submitted that which paragraph?
Your Lordship, in the middle part, this will be more relevant.
Huh?
The middle part,
Para?
page 3, furthermore, in
Page 9, page 9.
page 9. Para 5.
By the office memorandum dated, by another office memorandum dated
Para 5.
5/7/2019. The position, the earlier position is reiterated in that appointment on contract basis, comma, ad hoc, comma, fixed, comma, casual, comma, work charge, etc. are banned with effect from 6/6/2016. Full stop. Despite issuance of the office memorandum dated 6/6/2016 under the hand of the Chief Secretary to the Government of Nagaland, comma, the respondent number 3 proceeded to appoint the petitioner in complete disregard to the policy notified by the state by the office memorandum dated 6/6/2016. Full stop. MS, thus the appointment is of the petitioner is clearly illegal. Full stop. And in any view of the matter, comma, a contingency stroke casual worker appointee in any view of the matter, comma, no rights accrues upon a contingency stroke casual appointee who is appointed as a stopgap arrangement, comma, to seek permanency. I have considered the submissions of the Learned Council by the parties. Oh, Mr. Jamir has also referred to a decision of the Honorable Supreme Court of India in Rajvinder Singh versus State of Punjab and others, reported in 1988, supplementary SCC 428 to buttress his submissions. Para. The policy of the state government was notified by an office member. It is noticed that the policy of the state government has been notified by way of the, please take your seat, by way of an office memorandum dated 6/6/2016, issued under the hand of the Chief Secretary to Government of Nagaland. And the said FU's memorandum is on the subject, quote unquote, ban on appointment on contract basis. Full stop. From the office memorandum dated 6/6/2016, it can be noticed that any appointment to government service shall be made strictly in accordance with the existing rules stroke procedures in force, that is, through the Nagaland Public Service Commission within bracket NPSC or through open advertisement or through employment exchanges. And it has been made clear that all ad hoc, stroke casual, stroke temporary, stroke vouchers appointments are banned. Full stop. Any vacancy in the government post can only be filled up by appointing a candidate on the basis of open recruitment, and no vacancy can be filled up, even temporarily, in any other manner. Full stop. It has been further clarified that any appointment made on contract basis would be treated as null and void. Full stop. The same position has been reiterated in another office memorandum dated 5/7/2019, whereby instructions on the Personnel Information Management System, PIMS, were notified. Full stop. In the office memorandum dated 5/7/2019 also, it was reiterated that appointment on contract basis, ad hoc, stroke fixed, stroke casual, stroke work charge, etc., are banned with effect from 6/6/2016. In the face of such directives of the state government, despite such policy of the state government notified by the office memoranda dated 6/6/2016 and 5/7/2000. No, 6/6/2016. The respondent number, the petitioner came to be appointed in a as LDA counter assistant on casual and temporary basis by virtue of the order dated 28/2/2017 by the respondent number 3, which was in clear violation of the state policy relating to ban on recruitment appointment on contingency stroke casual basis on a good repeat query contracts para on perusal of the letter dated 1/3/2022 of the respondent number 2, it is noticed that the state government has introduced a system of payment of salaries and wages through e-bill system based on the Personnel Information Management System within bracket PIMS. It was informed to the deputy commissioners that on and from March 2022, only e-pay bill system based on PIMS would be applicable and no other system of payment of salaries and wages would be enforced. First of all, observing that the deputy commissioners had made certain contingencies to casual appointments in their offices on exigency and as stopgap arrangement till the conduct of recruitment processes through the district level recruitment board. The deputy commissioners were informed not to continue with such contingencies to casual appointees beyond 28 to 2022. And they were further directed to terminate all such contingencies to casual appointees immediately. It was only pursuant to the letter dated 1/3/2022 of the respondent number 2, the respondent number 3 passed the order of termination on 9/3/2022. Post of para. It is not in dispute that the petitioner was appointed on 28/2/2017 purely on temporary and casual basis, and his service was liable to be and it was specifically made clear in the order dated 28/2/2017 that his services would be terminated, were liable to be terminated without any notice posted. The petitioner has not been able to establish that by virtue of his continuance as a casual LDA counter assistant. Any right has been accrued to him to be a regular appointee. Post of. Unlike a regular appointee who is protected by the constitutional provisions, a casual appointee like the petitioner whose appointment was not preceded by any kind of advertisement and selection process is not protected, cannot claim protection under the law for continuance in service. Post of. A case, by the very nature of appointment, a requirement of a contingency stroke casual employee is a period of service of a casual stroke contingency employee is as per the requirement of the employer. Full stop. The petitioner herein was only appointed as a contingency to on casual basis and as a stopgap arrangement. Full stop. Whether a regular selection process for filling up a post by a selection process through the district legal recruitment board is immaterial if the employer finds that there is no necessity to continue with the engagement of a casual stroke contingency employee who was appointed as a stopgap arrangement. As such, the contention advanced by the learned counsel for the petitioner on the issue after consideration, deserves to be rejected. Fair. In Rasbinder Singh, the petitioner was an ad hoc lecturer who was appointed for a term. Apprehending that he was likely to be removed from service to deprive him from his vacation salary, the petitioner approached the court. The Honorable Supreme Court of India found that there was a practice of the respondents to appoint fresh people every time in place of ad hoc lecturers. Finding that a number of other petitions were allowed, were disposed of, allowing the ad hoc teachers to continue in service until persons regularly selected by the Public Service Commission were appointed in those posts. It was observed that the respondents ought to extend the benefit. It was observed that it was observed to be improper to drive the ad hoc teachers sorry, the ad hoc teachers were allowed to continue until regularly selected persons. Full stop. The position existed at the time when the decision in Rajbindra Singh was rendered is not applicable after the Constitutional Bench decision in state of Karnataka versus Uma Devi, 2006,
One SCC.
one
Four
SCC,
SCC, page 1.
page 1.
Lodge.
Full stop. But at this stage, Mr. Full stop. In view of the above discussion and for the reasons assigned therein, this petition is found to is found bereft of any merits and deserves to be dismissed. Full stop. It is accordingly ordered. Full stop. At this stage, Mr. Jamil, Council for the petitioner has submitted that the petitioner is still a petitioner still has the age to apply
Lodge.
for posts
Lodge.
to apply for post post in the government,
Lodge.
post in the state services, as he is about she
Lodge.
she is about 30 years of age
Lodge.
as on date. Full stop. Any qualification is mentioned?
No, Lodge.
LDM is definitely
Lodge.
As the petitioner has gained experience of about 5 years, an observation be made as regards giving weightage to the petitioner in the event the petitioner submits her candidature for a vacancy, regular vacancy in future through regular selection process. Having regard to such submission, committee is observed that if the petitioner applies in future for any regular vacancy commensurate with her educational qualifications and participates in the selection process, the appointing authority, the petitioner is at liberty, will be at liberty to submit a representation to grant her due weightage for the experience the petitioner has gained, petitioner gained during her service, during the period from 17. What is the date?
28/02/2017, Lodge.
28/02/2017 to 1/3/2022 as a LDA
Counter assistant.
counter assistant in the office of the General Administration Rest House Ukha
Under the establishment of Deputy Commissioner.
in the under the establishment of the Deputy Commissioner Ukha.
Walker, Lodge.
My humble request, Your Lordship, in my submission, like the last part, if it can simply be put that like it, instead of using the Chief Secretary, Your Lordship, if it can simply be put that like it was appointed, the petition was appointed without the approval of the government. I think, Your Lordship, if that can be modified, Your Lordship.
Without approval,
The chief secretary thing and that can